Hi there, it's Tamara Doris and another little episode for you on California real estate law. I had to be a real estate attorney is what I ought to do. Anyway, on the purchase agreement, there's a space that's got really bold print, and it requires that the buyers and the sellers initial it. And usually people trust me, they say, oh, she's a real estate professor, oh, she's been doing this for 20 years, but sometimes I like to show off and explain why. The reason that it's so important that you initial this arbitration mediation clause, both the buyer and seller, is because what it says is that the person signing it agree that should there be any miscommunication, I can't imagine that happening in real estate, or some kind of an issue, that both parties agree to mediation and arbitration. Now, what that's all about is a whole other ballgame, but basically it assures that we'll have a quick, speedy process. Because the California court system, if you know anything about it, it's quite congested. So what this means, let's just say you're selling a house, and you don't agree to that. So you and the buyer do not sign, do not initial the arbitration clause. Something goes wrong, someone's going to sue somebody. What happens now? Your property is tied up in court. And let me just tell you, it happens and it takes forever. You could be looking at not having your house sold for a number of years. Yes, I said years. Whereas mediation and arbitration is a third neutral, fair person, maybe a retired judge or an attorney or something like that, but someone who's fair, and then you're going to be able to have it taken care of in a speedy, quick process. So that's my tip for you today. Make sure you initial that. Make sure that you understand that what you're doing is protecting yourself, not hurting yourself. If you have any questions on real estate, give me a call, 916-482-5834, and have a terrific day. Thank you.